So first thing I want to go over is a little bit of background. I'm sure a lot of you are familiar with debt collectors. I mean, if you aren't, let's just leave it at that. But debt collectors play a really critical role in markets for consumer financial products and services. Credit markets function because lenders expect that borrowers will essentially pay them back. That's always the hope. In consumer credit markets, what happens is if a borrower fails to pay what they owe per terms of whatever loan arrangements they agree upon, creditors often engage with reaching out to debt collectors. And they try to attempt to recover the amounts due, whether it's through the court system or through a lot less formal demands for repayment. And, that's what these rules are about in high-level view. So in general, third-party debt collection creates the potential for a lot of different failures. Consumers could choose not to repay their loans, and as a result, debt collectors do not have the same incentives that creditors have to treat consumers fairly. And there are certain provisions of the FDCPA, which we'll go into in a little bit, that help reduce market failures in case a debt collection doesn't meet its goals and objectives. So any restriction on debt collection, it could reduce the repayment of debts. It does provide a benefit to some consumers who owe debts and an offsetting cost to creditors and also debt collectors. A decrease in repayment will in turn lower the expected return to the lender, which obviously has negative implications. This could lead lenders to increase their interest rate and other borrowing costs, and even restrict availability of credit to certain borrowers, typically more the higher risk end. Now, because of this, policies that increase protection for consumers with debts in collection, it usually involves a trade-off between the benefits of protections for consumers and also the possibility of increased costs of credits and reduced availability of credit for any consumers they deal with. So whether there is a net benefit from this depends on whether consumers really value the protections enough to outweigh any associated increase in the cost of credit or the reduction in availability of credit. We're going to go into the FDCPA shortly, but I want to give you a little background before we do. So the proposal as it stands right now would further the FDCPA's goals of really eliminating abusive debt collection practices and also ensuring that debt collectors who refrain from these practices are not disadvantaged, and that's the big key. But it is not, at this point, right now, it's really not clear at this point, based on the information available to the CFPB, whether the net effect of the proposal as they stand today and their different provisions would be to make it more costly or less costly for debt collectors to recover any unpaid amounts that they're tasked with. So basically, the proposed rule would benefit not just consumers, but also debt collectors. And it does so by increasing the clarity and certainty about what the FDCPA prohibits and also what it requires. Anytime a law is unclear, it's more likely than the parties will disagree about the law requirements. And the end result is, as you guys can imagine, legal disputes tend to basically arise, and the costs of the legal disputes and litigation is a lot of money out of pocket for the lenders and also the debt collectors. Now, a real important element is that the cost of resolving all these legal disputes, the costs really escalate because you have numerous consumers who are either in default or owe a significant amount of money. So those direct costs of not just the proceedings, but also to legal and compliance, auditing, various legal advices they receive from external law firms, as well as direct costs from avoiding collection practices that might be both effective and legal. Now, in some cases, debt collectors seeking to follow the law and avoid any potential litigation, because obviously that is the goal, they've adopted practices that are not economically efficient at this point, and with costs that exceed the benefits of consumers or even impose more costs to consumers. So it's a little bit of trade-off. And as I mentioned at the beginning, this proposal has received numerous comments. We're looking at 14,000 plus. I do not know if that's a record as of this point, but there's been a lot of back and forth about which provisions of the proposal will move forward and what won't. I mean, this has been going on, I think, a little over 2 years now, somewhere at that point. So we'll see where it ends up. Now, several provisions of the proposed rules would likely change the way debt collectors communicate with consumers, and we're going to talk about that a little bit more later on in this presentation. Also, the potential impacts that these provisions are likely to interact with each other in ways that are difficult for, right now for the CFPB to predict. So even if rules go into effect, there's always a period, maybe a grace period or some type of period of time where they want to measure the impact. And they have the opportunity to make amendments to the rules or regulations that have been issued. So CFPB has been working on this for some time, and hopefully the testing period commences relatively soon. So I did want to go over a little bit of background. Here's a slide, apologies for that. Now, with the FDCPA, now the CFPB proposal is really to amend Reg F, which, as you may or may not know, it implements the Fair Debt Collection Practices Act, the FDCPA. Now, the CFPB's proposal would essentially amend Reg F as it currently stands to prescribe federal rules governing the activities of the practices of debt collectors today. Also, the CFPB's proposal would address communications in connection with debt collection. Again, we'll talk about that a little bit later on. And this is really in the sense of the practices that involve harassment or abuse or even false or misleading representations and overall unfair practices in collecting of the debt from consumers. Now, also, it would clarify requirements for certain additional disclosure related and record retention requirements. So those will be spelled out as well. Now, the FDCPA established certain consumer protections, but since there were a lot of questions that arose, including the relation to communication technologies that did not exist when this was originally rolled out. Now, just taking a step back, the FDCPA was rolled out, I believe, in '77. So you're talking 40 plus years ago. So yes, technology is a tad different these days. And a lot of debt collectors, the way they communicated in the past is not really the way they're communicating now because of mobile phones, email, and text messages. So the use of technology these days is going to impact the proposed rules when they do hopefully go into effect soon. Now, the FDCPA, it was the first agency to prescribe rules for collection of debts. Now what the CFPB is going to do, it's going to propose how to clarify how debt collectors could use those newer communication technologies in compliance with FDCPA, and this will really help with the overall process. And if you're talking about an efficiency standpoint and reduction of costs overall, this will really benefit not just the debt collectors and the issuer, but also the consumer. So the proposed rule primarily on its authority is to issue the rules that implement FDCPA. We're going to go through each aspect of the rules. Well, hopefully we can get to as much as possible. But one thing I do want to mention When we go to Q&A at the end, if there's something that I didn't cover where you have a question, you could always reach me after the fact. So Sarah will forward me any questions on anything I might not have touched, or if we run out of time, you could always reach out to me for any questions in general. Now, the proposed rule essentially has 4 different parts. And, this is really important how it breaks down. You have subpart A. Now, subpart A contains basically general applicable provisions, such as the definitions that would apply throughout the regulation. B contains proposed rules for the FDCPA covered debt collectors. C is reserved for any future debt collection rulemakings, which we'll touch on a little bit later on, at least some of them. And then you have Part D, which includes miscellaneous provisions. And I'll try to touch the ones that are, I guess, more important at this point. Now, the communication proposal, I just find this interesting because of how far we've come since the implementation of this regulation back in the 70s. So debt collection efforts often begin with, when a debt collector reaches out to you numerous times to collect any unpaid debt. Now, communicating with a debt collector, it also may benefit a consumer by helping the consumer either resolve a debt that they owe or identify and inform the debt collector if the debt is not something that they owe. Basically if there's a mistake, and that does happen a lot. So debt collection communications, they also going to constitute more unfair practices, anything dealing with false or misleading representation, and also the harassment or abusive practices that have been in effect for a period of time, and that's really important. And, as I mentioned earlier, the FDCPA was enacted 43 years ago. And, the communication with technology has changed it's changed drastically. People today are more used to dealing with emails, text messages, or, using the web at a different capacity. So this is definitely going to offer greater efficiency for the debt collector. And I think it's going to also include more convenience and hopefully more privacy. But there's always practices where privacy doesn't always hold, but those are the essential goals. Now, the new technologies, and hard to say it that way, but email, text, the consumers will also have greater control over the timing, frequency, and the duration of communications with debt collectors. Basically, for example, let's think about it. By choosing when, where, and how much time to spend responding to a debt collector's email. So debt collectors also may find that these technologies are more effective and efficient means, especially with documentation purposes and follow-ups. So the technology aspect will definitely be enhanced. Now, to address concerns about debt collection communications and also to clarify the application of FDCPA, the CFPB is proposing really 5 different points. One, the first point, which is important, is limited content messages. So this would essentially identify what information a debt collector must and may include in the message left for consumers that they're trying to reach. This definition would also permit a debt collector to leave a message for a consumer without communicating with a person other than the consumer. So that makes life a little bit easier. The second point is it would clarify the times and places at which a debt collector may communicate with a consumer. So there'll be more controls over that, which is a good thing. Point 3, a consumer can restrict the way to which a debt collector communicates by making sure that, a certain type of communication, let's just take email, is used over other methods, or it could be text, or it could be whatever the communication method is, but the consumer can restrict the way they're communicated with. 4, it's also going to clarify that a debt collector is prohibited from placing a call to a person more than 7 times within a 7-day period. I mean, that's excessive. And, there were points in time where debt collectors would call people 2, 3 times a day. So there's a little bit more controls in effect with this proposal. Still, 7 within 7 days, I still view as very excessive. And then the last point, the proposal will include, new technologies, which I mentioned. So it will help with preventing, harassment, abuse, or, misleading representations, and also a lot of unfair practices. So, those are the goals with these proposals. Now, going on to the next point, this is a big one too. So prohibited communications with consumers. Now, the proposed rules to generally implement the FDCPA, it's going to talk a little bit more about communicating with consumers at unusual, inconvenient times and places, which I covered in one of the 5 points. So this would also prohibit attempts to make communications with which debt collectors already must avoid, given that a successful attempt would be, a violation under FDCPA. So those violations will be clarified and more granular than they have been in the past. Also, the proposed rule, again, as it stands, would interpret the FDCPA prohibition on debt collector engaging in any opportunities to harass, oppress, or abuse any person whenever they're making a call or collecting a debt in any capacity. So the communication element is going to be a lot more structured, hopefully, going forward. So debt collectors are already prohibited from communicating with consumers at a time or place that is known or should be known to be extremely inconvenient to whoever they're calling to collect the debt. So the CFPB expects that debt collectors already keep track of what consumers tell them about the times and places. They keep those records handy, so obviously they don't have to replicate the same issue more than once. And they have all records with communication with those consumers they're trying to collect on the debt collection. So one point that I read, which I also think is important about the CFPB, so the CFPB totally understands that many debt collectors currently employ systems and practices designed to limit communication attempts to consumers at those inconvenient times. So the proposed provisions might benefit customers or consumers, and debt collectors, providing further clarity in these requirements. So hopefully that will make everything, again, more structured and more efficient for all parties involved. So frequency limits for telephone calls and telephone conversations. I mentioned this before, but just getting a little bit more granular. So this proposed rule would prohibit a debt collector from placing a telephone call or engaging in conversations with, the intent to annoy, abuse, or harass anybody that they're trying to call. So the proposed rule provides that a debt collector violates the rule if debt collector places a telephone call to a person in the connection with the collection of a particular debt. So I mentioned earlier that there's 2 different ways. One, if they contact them more than 7 times within 7 consecutive days, and within a period of 7 consecutive days after having a conversation with the person in connection with the collection of a debt. I still think that is extremely excessive, so I am monitoring the proposed rules just because of my current practice and the organizations I work with. So the proposed rule would clarify the effect of complying with the frequency limits that a state debt collector currently, pursues. So again, the communication element and the frequency is absolutely going to be addressed. Now, the debt collectors try not to make the intent to annoy, abuse, harass consumers. But if you're calling them repeatedly, and also evidenced by what the CFPB has researched on, there's a point in time where the frequency becomes way too much, and you're constantly reaching out to consumers and trying to get that debt collection owed as any way possible. So these new proposed rules, again, hopefully they go into effect, will make everything a little bit more structured and easier. So the FDCPA also prohibits repeated or continuous calls, and this will all be spelled out. I'm not going to go into too much detail on this, but I do want to provide the high level as far as, what is the point in time where the annoyance factor goes up excessively. So that will be addressed. I'm sure you guys are familiar with do not call lists and other elements that make it more beneficial for the consumers. So next I want to go over is limited content messages. This is pretty straightforward. So the proposed rule would really define what a limited content message is and what it must include. So basic information like the consumer's name, request that the consumer reply to the message. That's always a good thing. Name or people that the consumer can contact to get back in touch. Telephone number, of course, and how the consumer could stop the annoying messages. Now, the proposed rule also provides what information needs to be included within the message. The salutation, the date and time of the message, whatever statements are made, more like the generic type, and suggested days and times for the consumer to reply to the message. So many debt collectors currently do not leave voice or text messages for consumers because of the risk of potential litigation. And anything that's documented or recorded is a record. It's a permanent record, and that's where a lot of the concern is. I think that's wrong, but anyway, so the CFPB expects that by clarifying the communication, that things will be better, better advantages for the consumer and the debt collector. So I guess overall, like in general, increased use of voice and text messages should make it more convenient for consumers to communicate with debt collectors, whether it's a debt that they actually owe or any mistakes that are made where a consumer is on the hook for something because of a mistake. And I'm sure a lot of you know that if mistakes are made, and it gets on your credit report, that's a really hard thing to reverse. And it could take months sometimes to have that reversal. So there will be some provisions in there to kind of assist along the way. Now, time-bar debt, prohibiting suits and threats of a suit. So the proposed rule would prohibit a debt collector from either suing or threatening to sue on a debt that the debt collector knows or should know is time-barred. So but a lot of the research and a lot of the historical side, multiple courts have held that the FDCPA prohibit this information or prohibit the suits or the threats. And that's a big part of it, the abuse, the annoyance factor, all of that. So there are benefits to the consumer from this provision, and there are a lot. They will most likely come from reduced payments of debts, and also help the consumer, get everything correct and avoid issues with credit agencies and follow-up. So let's go over the next part, which is communication prior to furnishing information. So this proposed rule would prohibit a debt collector from furnishing information to, a CRA regarding a debt before communicating with the consumer about the debt. So it's also a requirement that a debt collector could satisfy by sending a validation notice prior to furnishing this information. Now, the proposal would help ensure that consumers learn about an alleged debt before a debt collector furnishes any negative information to a CRA. So when consumers believe that the information is error, as I mentioned before, they will have the opportunity now to dispute the debt. So you have that additional time. If there is a mistake, before it goes to the credit agency, you can try to essentially have it fixed. So when debt collectors supply information about unpaid debts to CRAs, that could really hurt an individual's credit report. And these proposed rules will hopefully alleviate a lot of those issues. Now, if consumers are unaware that the information about a possible unpaid debt is being furnished to a CRA, then they may not realize that their ability to get credit or even employment, buying a house, may be affected by the debt on their credit report. So, an error on a credit report for a consumer, it could hinder them in so many different ways. And like I said, it's very difficult to have that lifted, and it could also take months to do so. So as far as other benefits, for the consumers, CFPB really wants to know how the frequency consumers are unaware of bad debts that have been furnished to the credit bureaus, and the overall benefit to consumers of becoming aware they had a debt in collection. Also, when I was earlier today, when I was reading a little bit more about this, in a lot of cases prior to these proposed rules, consumers would not be affected by this provision because many debt collectors already send validation notices before furnishing information to the CRAs. Many other consumers would not be affected because the debt collectors will not do so until, the frequency of the communication hits a certain point. So some debt collectors are currently dealing with this practice, but at least these new provisions will essentially put it written in stone for everybody to follow, and we'll have some real consistency with this information. So moving on to the prohibition on the sale or transfer of certain debts. So this proposed rule would prohibit a debt collector from either selling, transferring, or placing for collection a debt if the debt collector knows or should know that the debt was paid or settled. So if the debt was discharged in bankruptcy, or say an identity theft report was filed with respect to the debt, which would definitely help. And the CFPB totally understands that debt collectors generally do not sell, transfer, or place for collections debts if they have reason to believe the debts cannot be collected because they have been paid, or they were settled in some other method or means. And it could be within bankruptcy or any other proceedings where it is settled. So once it is settled, the purpose is really to take effect immediately for a consumer or within a certain period of time, and not let it linger and have other negative effects for the consumer. So the notice for validation debts, now specifically, this proposed rule provides the debt collector must provide the consumer. So the proposed rule would interpret FDCPA content requirements and also require that validation notice includes certain information about the debt and also what protections the consumers have. And what I mean by that is with respect to debt collection that debt collectors do not currently provide on validation notice. So another thing, the proposed rule would set forth generally formatting requirements and permit debt collectors to comply with these requirements by using what the CFPB has, a proposed model validation notice. And this would permit, but not really require, debt collectors to provide a consumer the validation notice translated into any language if debt collector also sends an English language validation notice. So there are certain ways where this proposal or the validation information could really benefit consumers. And I'm just going to go through them pretty quick. So one is disclosures would provide more information about the debt, which may help consumers determine whether the debt is theirs or whether the reported amount owed is accurate. The second one, the notice provide a plain language disclosure of the consumer's rights in debt collection, which meaning like their right to dispute, which should help consumers know their rights and what options are available to them. Part three, the validation information would include consumer response information that should make it easier for consumers to take certain actions, and meaning by that, disputing the debt at hand. And lastly, the proposed model validation notice form. So this is really intended to provide information to consumers in a more appealing and a lot easier to read format, because a lot of the notices beforehand were very legal in nature, and to be able to interpret them, a lot of consumers had issues with that. So they didn't essentially have everything plainly spelled out for them on the repercussions and the ways to remediate any negative impacts. So the benefit of providing more and clearer validation information, the impact of this additional information on consumers' ability to recognize their debts compared to what is currently provided on validation notices will be really helpful to consumers. The proposed validation information, which would include more specific details about the debt, and this would include like the the debt's account number or the consumer's account number, and an itemization of that particular debt. So, also in my reading, I read in regards to what the CFPB believes in this case, it would really just make it easier overall for consumers to determine the amount they owe and also reduce the likelihood of incurring costs due to mistakes. And there could be a lot of negative repercussions, where there have been in the past, and hopefully this will alleviate a lot of that. So electronic disclosures and communications. So this proposed rule includes provisions that the CFPB expects would encourage debt collectors to communicate with consumers by email and also text messages more frequently than they currently do. So with respect to the validation notice, and I mentioned this before, the proposed rule specifies methods the debt collectors would be able to use to send notices by email, or even a hyperlink to a secure website in a way that complies with the validation notice requirements. So basically, with any communications about the debt, this proposed rule specifies the procedures that debt collectors need to follow, whether they're communicating via email or text message. So, and with technology the way it is, compared to when this was originally rolled out in the 70s, there were a lot of changes that needed to be made. And so hopefully this will come out relatively soon. The consumer disclosure, and I'll just go over this fairly quickly. So the FDCPA requires that a debt collector send a written notice to the consumer, and it is actually within 5 days of the initial communication that contains certain information about the debt and also the actions the consumer can take in response to that request. So the information a debt collector must provide to a consumer at the onset of the debt collection, what the CFP is proposing is a few different methods. So one, to specify that debt collectors must provide certain information about the debt and the consumer's rights. The CFPB also proposes to require a debt collector to provide information that a consumer could use to dispute the debt. So it could be any information that they can to essentially fight this issue. Secondly, a notice that a debt collector could use to comply with the FDCPA, and also the disclosure requirements, which are going to be a little different than the past. Third point, it also includes steps a debt collector must take to provide the notice and other required disclosures electronically. So that will be a little bit more structured. And the last point, safe harbor, there is a safe harbor that's embedded in it. And if a debt collector complies with certain steps when delivering the notice in email, this debt collector's initial communication with the consumer will be entered as such. So these 4 points are part of the proposal. I think the safe harbor element could be amended a little bit further. I did do some reading a little bit last week, so that is also where a lot of the comments were generated, and I mentioned 14,000 plus. So I want to take a look at additional proposals. So I'm just going to touch on this pretty high level. So the proposal is also going to address other consumer protection concerns. One, as you can see on the slide, a personal representative of the deceased consumer's estate is a consumer, which addresses the communications in connection with the debt collection. So this would allow a debt collector to discuss the debt with somebody else if the consumer passed and could deal with the consumer's estate. 2, it prohibited a debt collector from furnishing information about a debt to a consumer agency before they communicate with the consumer. Obviously, giving a consumer the heads up about a debt or a debt that might not be theirs, will provide a little bit more guidance and help so it doesn't end up on CRA. And then lastly, to prohibit the sale, transfer, placement for collection of the debt if the debt collector knows or should know that the debt has been paid or settled or has been discharged in bankruptcy. So those are 3 additional proposals that the CFPB currently has. And this might be modified. I read somewhere where there was about 1,200 comments pertaining to these additional proposals. And there's hopefully going to be a little bit further changes. So miscellaneous provisions, there's the record retention is a key one. So this proposed rule would require a debt collector to retain whatever evidence of compliance with Reg F. The purpose of the record retention requirements, the ultimate goal is to promote effective and efficient enforcement of Reg F. And the retention period must be long enough to ensure there is access to evidence that the debt collector performed the actions and also made the appropriate disclosures. So the CFPB is proposing 2 elements that require a debt collector to retain information or retain evidence of compliance on the date the debt collector begins collection activity on the debt and ending 3 years after. These are 2 different points. The debt collector's last communication or attempted communication, the debt is settled, discharged, or transferred to the debt collector or another debt collector. And it's also going to require debt collectors to begin retaining evidence of compliance when collection activities begin, which should provide an easier start date. Now, the proposed rule is not limited to just communications or attempted communications with a consumer. Communication with any person may serve as the end date from which the retention period may be calculated. So essentially, if you look at it, it's 3 years approximately, give or take. And this proposal will put that more into effect. Now, another important element is the relation to state laws. So the FDCPA provides that the Act does not alter or exempt any person from complying with the laws of any state unless to the extent that those laws are inconsistent with any provision of the Act. So basically, if a state law is not consistent with the proposed rule, if the protection for any consumer is greater than the protection provided by the state. And a lot of these questions arise because state laws could be either more stringent or less stringent than the federal regulation that is issued. Now, some states and localities impose their own disclosure requirements on debt collectors. There is, and I think I read this the other day, there is some concern about the possible overlap or consistencies between even state and local disclosure requirements. So hopefully this will be spelled out a little bit more in detail. Now, I also want to touch on future debt collection rulemakings. Now, there's a lot of proposals here, and there's a lot of information that needs to be, I guess, vetted a little bit more clearly, so there is essentially a path to success. Now, one thing is, now the CFPB is going to monitor the progress to see if anything's going to be amended. I put that under future debt collection rulemakings because whatever's said at the beginning is not how it's going to end up. There's going to be amendments based on feedback they receive from financial institutions, debt collectors, and consumers. So also the CFPB plans to test consumer disclosures related to time-bar debt, and then after testing, they're going to assess whether a debt collector must disclose that the debt collection cannot sue them because of the age of the debt. At a later date, the CFPB could release all their findings and the cause and also the impact that they're going to have. So, it is important that the stakeholders will have an opportunity to comment on the testing and the outcomes from such, and how they're going to be involved in the final rule. So, regardless of what it is today in the proposal and how it's going to be issued, there are going to be changes. I mean, I've seen it for a long time. You have to get the basic look and feel of how it impacts consumers or all parties involved and what are the repercussions. So, as it stands right now, we'll see what happens in the next couple of months. But as I mentioned, this has been a lot of back and forth. And I personally, I've seen a lot of comments on new issuance of rules and regs, but 14,000 plus is a lot. So with that being said,